This is the FM Gold channel of All India Radio. In the program News Analysis, now we bring you a discussion on Centre's review petition on Supreme Court's ruling on SC/ST Act. The participants are Amit Khemka, legal expert, and Nikunj Garg, journalist.
Today, in a decision of far-reaching ramifications, Government of India has filed a review petition in the Supreme Court against one of the judgments of the Supreme Court, which ensured certain safeguards from the judicial point of view, and this judgment was pronounced by the Supreme Court itself. Mr. Khemka, what is the contention of the Government of India? Why have they gone to the Supreme Court in a review?
See, Nikunj, let us understand what the Supreme Court has said. And to my mind, not exactly, the public perception could be something. There is Section 18 in the SC/ST Act which says that the provision of anticipatory bail will not be available to an accused under the SC/ST Act. And that provision was challenged earlier in the Supreme Court, and its virus was upheld. Its constitutional validity was upheld. But now, over the years, the Supreme Court and the different courts have seen that even where there is absolutely no case made out, when it is prima facie a false case or malified case or is actuated by certain other extraneous reasons, even there the accused, especially in the government, especially the functionaries of the government, they were harassed by such complaints. There were misuse of it. So the only exception the court has carved out, it could be said technically that it amounts to legislation, but what the court has said is that if prima facie no case is made out, and if it is visible that it is actuated by malifieds, then in that case anticipatory bail would still be applicable. That is all the Supreme Court has said.
It is an important point that you raise. It is important that we clear and clarify it for our listeners that the overall SC/ST Act or the protection offered by the Act has not been diluted at all, other than the fact that the provisions of anticipatory bail also are available to the accused now.
Yes, only to those accused where it can be shown prima facie that the SC/ST Act is actually not applicable. From the facts of the case, if it is a malified case, if it is not made out, then in that case, just because of the technicality of Section 18, the anticipatory bail would not become unavailable. It will be available. But to other accused, where it can be shown that the offence is made out, then the anticipatory bail provision is still not available to the accused. So, Supreme Court actually tried to draw a fine distinction or draw a line so as in an anxiety to try to make it more meaningful and not to allow its misuse. That was probably the intention of the Supreme Court. One could technically argue that if you are not holding Section 18 unconstitutional, then how could you actually change the literal meaning of Section 18? How could you provide your own interpretation to it? But very frankly, if the Supreme Court will not do that, if the Supreme Court will not come out with some interpretation which is reasonable, which will make the act more meaningful, then who will do it? Of course, the Parliament is there. So, I don't, personally speaking for myself, I did not see much of a problem with the judgment. However, the senior officers of the government have seen that yes, technically speaking, it amounts to legislation. So, if at all a legislation has to be made, we in the Parliament will make. So, that is why the government has filed this review petition.
The principal contention is that this amounts to a fresh legislation. And fresh legislation obviously can be enacted only by the Parliament. So, this is the principal contention, and that which also by default would mean that the original act should stand till the time Parliament in its wisdom decides to amend that.
Very rightly. This is technically, if you go, because a provision whose constitutional validity has already been upheld by the Supreme Court, unless this court had disagreed with the earlier judgment, then in that case also it should have gone to a larger bench. So this bench could not have
delivered the judgment.
So it actually amounts to changing the earlier judgment which had upheld the constitutional validity of Section 18. So that legally speaking, the government is right. that technically speaking, government is right, but to make a political issue out of this judgment, to say that this judgment amounts to some kind of an atrocity on the SC/STs, I don't really agree with that. Because this particular judgment, if you go through the judgment, the intention of the judge is absolutely clear. The intention is only to provide safeguards against the misuse of the Act. It is not, wherever there is a bona fide complaint, there is nothing in this judgment which creates any hurdle in the way of prosecution of a bona fide complaint.
Now, in that sense, you make a very valid point that eventually it is the investigating officer who has to decide whether the bona fides of the complainant, bona fides of the complaint are established and accordingly act. So the act in per se has not been diluted, and therefore the aggravation or agitation in the minds of the SC/ST community should not be there.
Absolutely. There are two things which the judgment has. One, I told you about anticipatory bail. The other thing what the court has done is, which again and again Supreme Court has been saying so, that power to arrest does not mean arresting.
A person should be necessarily arrested.
The power, of course, rests with the police. Power, of course, is with the investigating officer. But there have to be reasons for arrest. What are those reasons? The reason can be if a person is trying to repeat the offence, or if there is an apprehension of his repetition of the offence. Of course, he has to be arrested. If he is trying to influence the investigation, if he is trying to influence the witnesses, if he is likely to run away. Now, these are the things, these are the considerations only because of which a person has to be arrested. If the person is cooperating, if there is no likelihood of his doing anything, again, if he is a government servant, for example, he is not running away anywhere. So, why should the first step should not be arrest? Therefore, the court has said that whenever there is an arrest, especially of a government servant, especially of a person whose arrest is likely to affect the public administration, you must take the sanction of a senior officer. So, I personally speaking, anything so unreasonable in it. Of course, the arrest should not be the first thing
in the investigation.
The first thing should be a preliminary inquiry. That is what the Supreme Court has said in this judgment. The Supreme Court only says that unless you have come to a reasonable conclusion that the arrest of a person is necessary, after having come to the conclusion that he has committed an offence, prima facie you see that the offence has been committed, then also his arrest is necessary, you must arrest him. And then, of course, he may not get bail, then it would be in the hands of the court. But to go ahead and the very first step in the investigation, just because it is under SC/ST Act, should not be that a person is arrested and sent to gallows. That should not be the way. So that is the only intention. Really speaking, somebody has to read the judgment before making so much of noise about it.
Mr. Khemka, is it that certain sections of our polity and certain sections of the civil society is trying to encash this judgment for its own political ends?
Nikunj, long back, Dr. Ambedkar said that religion only divides. So the caste has always been used by all the political parties. No political party can claim holier than thou. Every political party has made use of it, or if I may say so, misuse of it. While the religion and the caste should be something which should unite people, we must have the power to respect each other's views, each other's religious faith, trust. Rather than that, we are in a kind of a state where we are trying to get into a game of one-upmanship, that my religion is better than yours, or I belong to a caste which is better than yours. So that is the absurd thing. Unfortunately, we are getting educated, more literacy is there in this country, more we are becoming communal. So that is a very strange thing which has been happening. We were not that communal when I was a kid. When I started profession for 34 years ago, we were not that communal. Today we are much more communal. So of course it is abhorrible that any political party or any political group is trying to make use or misuse of this kind of a thing. This act has been made with a very, very solemn purpose, that people who are weak, people who
are at the bottom of the pyramid, they should have a safeguard, they should feel safe, they should feel that if somebody tries to misuse
his dominant position, and if try to suppress them, then the law is there to protect them. That was the purpose of this act. The purpose was not to divide people on caste lines. That was certainly not the purpose. And that is exactly, I think, Supreme Court has rightly tried to draw a line or probably create a balance between the harsh-looking provisions of this act and the reasonable implementation of the act.
So, in a way, do you think that then if there is absolutely nothing unreasonable in the order, then you think that other than the fact that the opponents probably hijacked it for their own political purposes, do you think the government also in a way failed to communicate enough that the overarching protection to the SC/ST communities has not been taken away? And if there is an aberration in the law, we will certainly go back again to the Supreme Court and get it rectified.
Nikunjai pointed out, the problem with the government is that technically and legally speaking, the Supreme Court has tried to legislate in this matter. Now, if they were to take a legal opinion from their Attorney General, the Attorney General will have to say that it amounts to
encroachment on powers of Parliament.
Power of Parliament. So, Attorney General will have to say that if they thought that the Section 18 is bad, then they should have referred it to the larger bench. They should have gone for striking down. It's constitutionally. So, there lies the catch. The catch is that technically speaking, legally speaking, you could say that the judges have stepped into a forbidden territory. But at the same time, if I see as a person who is concerned and who is involved with the day-to-day implementation of law, I find it quite a reasonable judgment. I find that it is not against any community. It does not dilute the provisions of the Act. It only tries to balance the alleged misuse versus the actual use.
But then, Mr. Khemka, the proponents of the overarching protection or the proponents of this act in tow before the amendment will say that each and every act is open to abuse. So why only amend this particular act which gives an umbrella of protection to the weakest sections of the society?
The Supreme Court has been doing it wherever this kind of situation. After all, let me say that I favor that there should be no special acts. I feel that it also amounts to ad hocism. Whenever you have special acts for everything, then it does amount to ad hocism and it is open to misuse. Because you are starting with a prejudice. Whether it is when you are trying to favor a woman or whether you are trying to favor a SC/ST or whatever.
Or maybe giving them extra protection.
Giving them extra protection. So ad hocism, there is a danger of falling into kind of a biased situation. But at the same time, every law has the potential of misuse. And Supreme Court and different courts, that is why we have a principle of harmonious construction. When we interpret the law, we are taught one method, harmonious construction. That is what the courts have been trying to do for time immemorial. That whenever they see that this is the misuse which is taking place, so they try to give it an interpretation which is harmonious with the intention of the act, which is commensurate with the purpose of the act.
Spirit of the act.
Spirit of the act. So that is how it happens. It has to be like that only. So there is nothing wrong in doing it. So I feel that misuse will be there and people will have ingenious methods of misusing it. But then we as the part of the legal system will keep on trying to stop that misuse.
It's a very technical subject, I must say, and you explained to our listeners very lucidly that. Thank you.
Thank you so much.
You were listening to a discussion on Centre's review petition on Supreme Court's ruling on SC/ST Act. The participants were Amit Khemka, legal expert, and Nikunj Garg, journalist. The program was produced and presented by the News Services Division of All India Radio. This program is also available on our website newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.